Followers, the unprecedented growth in the travel and tourism industry within the country during the last few years and the consequent economic and cultural benefits that such activities have generated have earned great credit for the travel agents, tour operators, hotels and related businesses. There has been growing public opinion for regulations for the industry due to immoral practices of some of the tour operators and agents. There are many regulations already in force to regulate the tourism organizations. Welcome to the episode on Need and Scope of Tourism Laws. In this episode, we will be discussing on the significance of tourism laws, and for better understanding, this episode is divided into 5 parts, namely meaning and definition of law, development of law, custom, overview of tourism laws and travel and tourism laws and regulations. Let us discuss about the overview of tourism laws. Meaning and definition of law. The term law denotes the principles and rules that governs and regulates social conduct and observance of which can be enforced through courts. According to Austin, law is a command of sovereign. In the words of Blackstone, law in its most general and comprehensive sense signifies a rule of action and is applied indiscriminately to all kinds of actions, whether animate or inanimate, rational or irrational. In the legal sense, the law may be defined as the system of rights and obligations which can be enforced in a court of law, and it includes all the rules and principles which regulate our relations with other persons and with the state. Characteristics of law. The essential characteristics of law are: law is body of rules and principles relating to actions of individuals. Law operates to regulate the external actions of individuals in respect of one another and in respect of entire social group of society. Law is applied in the administration of justice and law is enforced by the state. Branches of law. Law has several branches. They are constitutional law, administrative law, criminal law, civil law, commercial law, tourism laws, etc. Constitutional law means the rule which regulates the structure of the principal organs of the government, their relationship to one another and determines their principal functions. The rules consist of both legal rules and of usages commonly called conventions, which without being enacted are accepted as binding branch of the government. It is as old as the executive. Criminal laws are those laws with which the private rights of an individual are enforced. Commercial or mercantile law deals with the rights and obligations of commercial persons and organizations emerging from commercial transactions in respect of commercial property. Objective of law. The objective of law is to establish order and result of order that the commercial personnel are enabled to look ahead with some sort of security as to the future. Although human action cannot be reduced to the uniformities of nature, they have yet endeavored to be reproduced by law something approaching to this uniformity. Development of law. Law developed through the following 4 stages. In the beginning, law was made by the commands of the rulers believed to be acting under the divine inspiration. In the second stage, the command of the ruler crystallized into customary law. In the third stage, the knowledge and administration of customary laws goes to the hands of minority, usually of religious nature. This is due to the weakening of the power of original lawmaker and in the fourth stage, the codes, that is legislative acts, came into existence. The law is developed by passing legislative acts according to the needs of the society. Law and society. Law and society are very closely related. It is the aim of the law to bring about social and economic harmony. The law aims to bring about and maintain peace and order in the society. The purpose of the law is administer of justice without compromise. Law is the body of precepts in accordance with which justice is administered by authority of the state. Justice is an ideal relation among men. There are mainly four stages of legal development. Number 1, the stage of primitive law. Number 2, the stage of the strict law. Number 3, the stage of equity and natural law. And number 4, the stage of maturity of law. Constitutional Law of India. The Constitution of India came into force on January 26, 1950. It is a comprehensive written document containing 365 articles divided into 22 parts and 9 schedules. All public authorities like legislative, administrative and judicial take their powers directly from it, and the Constitution proclaims India to be a sovereign, socialistic, secular, democratic republic. Part 3, which form the characteristics of a democracy of the Constitution, guarantees 6 categories of fundamental rights, namely right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and right to constitutional remedies. Previously, the right to property was also guaranteed as a fundamental right, which has been eliminated by the 44th Constitutional Amendment Act 1978. Now, right to property is not a fundamental right and it is now only a legal right. Meaning of mercantile law. Mercantile law is that branch of civil law dealing with rights and obligations of mercantile persons arising out of mercantile transactions in respect of mercantile property. A mercantile person is a person who carries on commercial transactions and may be a single individual, that is sole trader, or a partnership or a company. Mercantile transactions relate mostly to what is known as merchandise or movable property or goods, as distinguished from immovable property is not confined to corporeal movable asset having a material form like a bag of rice or a bale of yarn. Even an incorporeal thing have no material form like a debt due from a person, or a share in a company is movable property. Thus, movable, that is mercantile property, is of two kinds, namely number 1, choose in possession, and number 2, choose in action. Number 1, choose in possession. Thing in possession. It means a corporeal movable whose possession can be maintained by the person having and entitled to legal possession even by the use of force, and a suit for recovery of possession of that identical movable property can also be brought. Chose in action, that is thing in action. It means a claim which can only be enforced by an action in a court of law. Thus, negotiable instruments like promissory notes, bill of exchange or checks, shares and debentures in companies and insurance policy, etc. are all examples of chose in action. Sources of Indian mercantile law, commercial law and business law. The main sources of Indian mercantile law are the English law, acts enacted by the Indian Legislature, judicial decisions and proceedings, customs and trade usages. Custom. Custom is the most ancient of all the sources of law and has held the most important place in the past, though its importance is now diminishing with the growth of legislation and precedent. Custom is a habitual course of conduct observed uniformly and voluntarily by the people concerned. Thus, custom is based upon popular practice. A custom may be customs without sanction and customs having sanction. The custom without sanction is a non-obligatory and are observed due to the pressure of public opinion called positive morality. The custom having sanctions are those customs which are enforced by the state. This may be divided into legal custom and conventional or usages. A custom may be a local custom or a general custom. Local custom is one which prevails in some definite locality and constitutes a source of law for that place only. Local customs may be geographical and or personal. This law is only for a particular locality, sect or family. A general custom is that which prevails throughout the country and constitutes one of the sources of law of the land. A custom to be valid must be proved as to its immemorial existence and observation, certainty, reasonableness, uniformity of operation, consistency, peaceful enjoyment and its conformity with law and public morality. Judicial precedent. The term precedent in legal manner of speaking means the guidance or authority of past decisions for future cases. Only such decisions as lay down some new rule or principle are called judicial precedents. Generally, judicial decisions make law but cannot alter it. Where there is a settled rule of law, it is the duty of the judges to follow the same. Each court is absolutely bound by decision of the court above it, and to a certain extent higher courts are bound by their own decisions. The decisions of a high court are binding on all the subordinate courts and tribunals within its jurisdiction. The decision of one high court will have only persuasive value in a court which is within the jurisdiction of another high court. But if such a decision is in conflict with any decision of the high court within whose jurisdiction that court is situated, it has no value and the decision of that high court is binding on the court. In a high court, a single judge constitutes the smallest bench. The bench of 2 judges is called the division bench. 3 or more judges constitute a full bench. The Supreme Court is the highest court and its decisions are binding on all courts and other judicial tribunal of the country. Scope of business law. The Indian Contract Act 1872 is the most important part of mercantile law. The Contract Act provides basis for other branches of commercial law or the business law or the mercantile law and the Negotiable Instruments Act, the Insurance Act, the Partnership Act, the Insolvency Act, the Companies Act, etc., which are all founded upon the general principles of the Contract Act. Therefore, the study of the law of contract precedes the study of all the other subdivisions of the business law or the mercantile law. Overview of tourism laws. Tourism as a product is made up of dreams, passion and challenges of delivering dreams. Hence, as tourism businesses are delivering services which are intangible, perishable and uncontrollable to some extent, there comes the need for business laws in the tourism industry, that is, a set of rules and regulations to govern tourism businesses. The existence of tourism businesses become all the more imperative because the tourism industry is interdisciplinary and in India, most of the tourism organizations are governed not only by national organizations, but also by multinational enterprises. There are chances of arising legal conflicts in relation to investment and management of tourism enterprises. There are no separate laws provided in the Constitution of India, but still there are various other laws from which the applicable acts are assembled and applied them to specific situations arising in the field of travel and tourism. Need for tourism laws. Need for tourism laws can be understood by going through certain aspects such as number 1, a tourism product is a combination of different components like the transportation, accommodation, entertainment and experience, all of which qualifies the satisfaction level of tourists. Tourism industry in general is all about creating intangible service product and to promise satisfactions on papers and brochures, and in advertising often exceeds a destination or producer's ability to deliver the satisfaction at the time of consumption. Tourism products are mere concepts at the time of purchase, and tourist satisfaction is more extensive, more complex and more difficult to regulate than physical components themselves. Number 2, tourist experience depends upon the expectations. In this market, no two individuals can perceive the things alike because the tourist service providers are selling dreams. When one embarks on a journey, individuals have a set of expectations. When these expectations do not turn into reality, this leads to dissatisfaction and comes up the need of laws to settle the issue. Tourism industry also faces some problems relating to the attitudes. Different people have different kinds of attitudes. Attitudes of the service provider of services depend upon situations as well as the background and mode. This results in service gap. So, in such a case where formulating of intangible product is concerned and formulation of a code of conduct is almost impossible, cases can be dealt with established laws and procedures than on personal judgments. Travel and tourism laws and regulations. Tourism is presently India's third largest export industry after gems and jewellery and ready-made garments. The most significant feature of the tourism industry is its contribution to sustainable human development, including poverty alleviation, employment generation and environmental regeneration, particularly in remote and backward areas. Tourism plays a major role in promoting large-scale employment opportunities. The tourism industry also contributes to the national integration. The sustained development of tourism as a national priority is important both from the point of view of economic growth and social integration. The Ministry of Tourism is assisted by the Department of Tourism headed by the Director General in the rank of Additional Secretary to the Government of India. This office provides executive directions for the implementation of various policies and programs. The ministry also has under its control a public sector undertaking, namely the India Tourism Development Corporation, that is ITDC, and other autonomous institutes, namely Indian Institute of Tourism and Travel Management, that is IITTM, National Council for Hotel Management and Catering Technology, Institutes of Hotel Management, Food Crafts Institutes, National Institute of Water Sports and Indian Institute of Skiing and Mountaineering, that is IISM. Functions of the Ministry. The various functions of the Ministry of Tourism are: number 1, policy and planning, that is formulating national level policies and programs for the development of tourism on a sustainable basis. Number 2, coordination, that is tourism development calls for effective coordination of all the concerned departments of the Government of India, state governments and some private sectors it also calls for the provision of leadership and guidance to the state governments. This crucial coordination is provided by the Union Ministry of Tourism. Number 3, infrastructure and product development, which refers to a major constraint in the growth of tourism in India is the lack of adequate infrastructural facilities including basic amenities. Large scale private investment has to be mobilized to achieve any significant improvement in the situation. The government plays a role of facilitator and preceptor by setting up lead projects and basic facilities apart from providing all the necessary support services to the process of development to achieve sustainable growth of tourism. Product development includes organizing of rural craft melas, festivals, fairs and adventure tourism. Number 4, regulation. The ministry is responsible for approving and classifying hotels, for approving travel agencies, tour operators, tourist transport operators, etc. and for ensuring that they meet the standards set by it. Number 5, human resource development. The ministry through the National Council and IITTM has standardized training facilities in travel and tourism management to ensure the availability of adequate trained staff for the tourism sector. Number 6, publicity, marketing and facilitation. To undertake effective publicity and marketing efforts in overseas markets and to maintain its existing market share, the ministry maintains field offices abroad. Number 7, research, analysis, monitoring and evaluation. Compilation of statistics and commissioning of research studies are important activities of the ministry to enhance the development of infrastructure and marketing in tourism. To sum up, law is the principles and rules governing and regulating the social conduct and observance of which can be enforced through courts. There are several characteristics and branches of law. Law and society are closely related. The main aim of law is to bring social and economic harmony among the members of the society. The Constitution of India has given 6 categories of fundamental rights and they are enforced by the law of the land. The sources of Indian mercantile law are the English law, acts enacted by the Indian Legislature, judicial decisions and proceedings and customs and trade usages. Tourism law is assembly and application of various other laws depending on the specific situations arising in the field of travel and tourism. Thank you.